Hi, good morning, everyone, and welcome to Tirigian Giving 2025 Employment Law Forum webinar series. Today's session is titled From High to Exit Understanding Employment Separation in Southeast Asia. In this session, we will explore aspects of termination law, applicable considerations, and guidelines for managing separation effectively across 5 jurisdictions, that is Thailand, Cambodia, Laos, Vietnam, and Myanmar. My name is Kantima and I will be the moderator for this morning. Before we begin, I would like to go over a few housekeeping notes to help today's session run smoothly. Firstly, this webinar is being recorded. We gladly welcome your questions throughout the session and invite you to write them anytime in the Q&A box located at the bottom of your screens. Secondly, as we have a large number of attendees today, all of you have been placed on mute, and our speaker will address your question during the Q&A session at the end of the presentation. Should you have any issue with the software, you can also type them in the chat box as well, and our IT team will be on hand to assist you. Lastly, your feedback is important to us. At the end of the webinar, a QR code will appear on the screen. Please take a moment to scan it and share your thoughts about these sessions. With that, this is now my privilege to introduce our speaker from 5 jurisdictions today. For Thailand, Kundusta will be the lawyer presenting today. She is a consultant in the Corporate and Commercial Department in Bangkok, and she handles a wide range of corporate and commercial matters, including labor and employment matters. In addition, she was recognized as the International Employer Lawyer by Tomorrow Lister 2024 publication, the only listed expert in Thailand. The next for Cambodia, please be introduced to Kun Jae. He is a partner and director of Tilikian Gibbin Cambodia practice, leading the Phnom Penh office commercial and intellectual property practice. He is ranked as a leading commercial lawyer in Cambodia by various legal publications. For Laos, please be introduced to Kun Sai Pin. She is an associate in Tilikian Gibbin Vientiane office, focusing on foreign direct investment, banking and finance, energy and infrastructure, and other corporate and commercial matters. For Myanmar, please be introduced to Kun Nue, who is a senior associate at Tilikian Gibbin Myanmar office, with a focus on corporate and commercial law. He is also involved in dispute resolution, intellectual property rights enforcement, and commercial litigation matters. He is a former prosecutor and is ranked as a leading lawyer in Myanmar. For last jurisdiction, Vietnam, please be introduced to Kun Saras. She is a counsel with the Tilikian Gibbin Corporate and Commercial team in Ho Chi Minh City. She has over 16 years of professional experience advising on Canadian and international law, and she is also recognized for her expertise in labor and employment by the legal publication. And now that we are done with the introductions, I would like to hand it over to our first speaker from Thailand, Kundusita, to begin the presentation.
Thank you very much, Kun Kantima. So we'll begin today's webinar by discussing termination of employment under Thai labor laws. Let's start with the definition of termination. Now, termination is defined as any act carried out by an employer to prevent an employee from continuing to work and to discontinue payment of wages, whether due to termination of their employment agreement or for any other reason. Note that this includes circumstances where the employee could not work and did not get paid because the employer could no longer operate the business. Termination under Thai law is generally categorized into 2 categories: termination with cause and termination without cause. And during today's session, we'll be discussing both termination with cause and termination without cause, as well as the employer's obligations under these scenarios. We'll start with termination with cause. These are circumstances where an employer is entitled to terminate an employee without paying statutory severance and without giving advance notice of termination. This means that the termination can be with immediate effect, and the employer is not required to pay statutory severance. The Thai Labor Protection Act specifies the exact circumstances whereby an employer is entitled to terminate an employee with cause. These are as follows. First is when an employee acts dishonestly in the performance of his or her duties. Second is when the employee intentionally commits a criminal offense against the company. Third is when the employee intentionally causes losses to the company. Fourth is when the employee performs an act of negligence which causes the company to suffer severe losses. Fifth is when the employee violates the work rules and regulations or lawful instructions of the company, and the company had already given a warning for an offense which took place within the past 12 months. Sixth is when the employee commits a serious violation of the work rules or the lawful instructions of the company, for which the company is not required to give a warning as this was a serious violation. Seventh is when the employee abandons work duties for 3 consecutive working days without a justifiable reason. Eighth is when the employee is sentenced to a term of imprisonment by a final judgment for any offenses other than those committed by negligence or a petty offense. And lastly is when the employee is sentenced to a term of imprisonment by a final judgment for offenses which were committed by negligence or for a petty offense, but which caused the company to incur loss or damages. So these 9 circumstances are situations which may constitute termination with cause. And as mentioned, during termination under these scenarios, the employer is not required to provide advance notice of termination, not required to make payment in lieu of notice, and the employer is also not required to pay statutory severance. Now, what are the employer's obligations in these circumstances? Well, even if the termination is with cause, the employer would still be obligated to pay wages, overtime pay, holiday pay, and holiday overtime pay through to the last day of work. The employer would also have to pay wages for any accrued and unused annual leave from previous years, which the employee may have carried forward, but this does not apply to annual leave accrued within the current year. And lastly, the employer would also have to pay other benefits under the employment agreement or work rules or regulations, which may have or otherwise already been agreed between the company and the employee. Now, to reiterate, in termination with cause, which are the 9 circumstances which was mentioned, no advance notice is required, and the employer can terminate an employee with immediate effect, and no statutory severance pay is required as well. However, it is important to note that if the cause of termination is not specified at the time of termination, it cannot be raised as a defense afterwards. This means that when a company is terminating an employee with cause, it is very important that the notice of termination clearly specifies the reasons for terminating the employment. And it's important that these reasons are accurate and also supported by strong evidence that the company has retained to ensure that the company's interests are adequately protected and in order to help defend the company's position in case the employee pursues an unfair termination claim. Now, we will discuss unfair termination claim a little later on in this session. So the circumstances which we discussed just now are regarded as grounds for terminating an employee with cause. Now, any other circumstances of termination which does not fall within what was discussed earlier, including termination due to poor performance, termination due to redundancy, termination due to, for example, business reorganization or restructuring, are all regarded as termination without cause. A common misconception would be that poor performance would be termination with cause, but if it does not fall within the 9 grounds specified earlier, termination such as termination due to poor performance will fall as termination without cause. Now, compared to termination with cause, in the case of termination without cause, there's additional obligations that are imposed upon an employer, namely that the employer has to provide advance notice of termination or make payment in lieu of notice, and the employer would also have to pay statutory severance based on the employee's last wage rate. In addition, the payment in lieu of employees' unused annual leave will include any accrued annual leave from the current year as well. Now we will go on to discuss a bit regarding the notice requirement and the statutory severance requirement, as these may lead to some points of confusion for companies. An employment contract would generally be an open-ended employment agreement, which means that there is no definite end date specified in the employment agreement. There would be a commencement date of employment, but no specified end date. In these circumstances, if an employer wants to terminate an employee without cause, either party, even if the employee wants to resign, so either party may terminate the agreement by giving advance notice to the other party at or before the payday in order for it to take effect the following payday. In short, this is often referred to as the one pay period notice requirement. This one pay period notice requirement is the minimum notice that the company would have to provide to an employee in the case of termination without cause. However, if the employment contract or the work rules specifies a longer notice of termination, for example, for higher level employees, it is common practice that the employment contract may state the notice period as 2 months or 3 months. And in this scenario, if the company wants to terminate the employee without cause, the company would have to comply with this longer notice requirement. Although the minimum period under the law is one pay period notice, if a longer notice is stated in the employment agreement or the company's work rules or policies, the company is obligated to comply with this longer notice period. The one pay period notice requirement is often misunderstood as 1 month notice, but I would like to clarify that there is a difference between providing 1 month notice versus one pay period notice. And the key distinction falls on the date which the company pays wages or salary to the employee. Now let's take an example of a company that pays salary on the 25th of each month. Now, if the company wants the termination to be effective 25th April, the notice of termination must be provided to the employees on or before the pay date in March, which is 25th March. Now, if the notice is given on 25th March, there's one full pay cycle between 25th March and 25th April. This means that the one pay period notice requirement is satisfied. We will now take another example, and let's say that the date of salary payment is still on the 25th of each month. Now, if the company has missed the 25th March payday and the notice of termination is given to the employee, for example, on 26th of March or 27th of March or any day before the next payday, but where the March payday has already been missed, the effective date of termination will be pushed to later to 25th May, which is the next payday in May. This is because the one pay cycle requirement was not met, and therefore the effective date of termination shall be moved to the following payday in the next month. Now, this can therefore mean that the notice requirement is longer than 1 month, which is why I mentioned earlier that there's an important distinction in between providing 1 month notice versus one pay cycle notice. And that is because if the pay date in a given month is missed, the effective date of termination will be pushed to later. In any case, employers may choose to provide payment in lieu of notice instead if the company no longer requires the employee to work and wants the employee's effective date of termination to be earlier. Payment in lieu of notice can instead be made to the employee to end the employment relationship quicker. Now, this example is the one pay cycle requirement, and I would like to reiterate that if a longer notice of termination is stated in the employment contract or the work rules, the company is required to comply with the longer notice period, and this is likely to be more common for higher level executives or more senior employees whose notice requirement tends to be longer. A common misconception is that probationary employees can be terminated with immediate effect without the one pay cycle notice requirement, and this is incorrect. A probationary period employment is handled as an employment agreement without a fixed term, which means that it is handled as an open-ended employment contract. So, unless the termination is with cause, if the company would like to terminate an employee during their probationary period, for example, due to poor performance or failure to meet the satisfactory requirement to pass a probation, the employer still has to provide at least one pay period notice requirement, even for a probationary employee. We sometimes see employment contracts state that the company is entitled to terminate an employee during the probationary period with a shorter notice, such as 7 days notice or even no notice at all. And it's important for companies to bear in mind that this is not consistent with the law. Probationary period employees are entitled to at least one pay period notice as well, same as regular employee. And if a longer notice is stated, a longer notice, which means longer than one pay period, the company also has to comply with this. Now, you can terminate a probationary period employee without providing advance notice of termination and without providing any payment in lieu of notice, only in the case of the 9 circumstances that constitute termination with cause, and then in that case, statutory severance is not payable. Another misunderstanding is also that probationary period employees are not entitled to statutory severance. However, the law does not distinguish between probationary and non-probationary employees. Therefore, if the employee's length of service at the time of termination is 120 days or more, even probationary period employees will be entitled to statutory severance. This is because severance payment obligations arises for employees whose length of service is at least 120 days. This is why it is common practice for companies to set the probationary period at 119 days so that the obligation to make statutory severance does not arise. But now, in all circumstances of termination without cause, regardless of whether there's a probationary period, employees whose length of service has reached 120 days, but length of service is less than 1 year, will be entitled to statutory severance of 30 days. And as you can see from the table on my slide, the severance rate increases as the length of service increases as well. Now, for employees with length of service of 20 years or more, the severance rate is capped at 400 days wages. And the severance pay is calculated based on the employee's last wage rate, which means their most recent salary before the termination occurs. It is also important to determine what the employee's wages amount is, because the severance pay or any payment in lieu of notice or any payment in lieu of unused annual leave is calculated based on the employee's wages. Now, any money which is given by periodic payment for which the employee does not need to submit receipts for reimbursement and which is paid in respect to the employee's normal work would constitute part of the employee's wages. However, money which is paid as welfare, which is not paid in respect to the employee's normal work and or requires reimbursement for expenses incurred, would not be regarded as part of the employee's wages. Let's take a few examples. Some common allowances that can be provided to employees in Thailand are housing allowance, transportation allowance, petrol allowance, and mobile allowance. Now, if these allowances are paid on a periodic basis by the employer to the employee, for example, in a monthly salary, in the pay slip where no reimbursement is required, no proof of receipt is required, and is paid in a fixed lump sum each month, these amounts are likely to constitute part of the employee's wages and included as the basis of the employee's wages when calculating amounts such as statutory severance, payment in lieu of notice, and payment in lieu of any unused annual leave. However, any bonus that is paid will not be regarded as part of the employee's wages, for example, any discretionary bonus. So when calculating statutory severance, any unused annual leave, and any payment in lieu of notice, it is essential for the company to ensure that the correct figure is utilized as the basis for these calculations, and that any fixed lump sum allowance that is paid, which does not require receipts for reimbursement, it should be considered whether this is included as part of the employee's wages to ensure that all amounts paid are accurately calculated. Under Thai law, if an employee is terminated, they have a statutory right to pursue an unfair termination claim at the Thai Labor Court. Even if the company has made all payments due upon termination, has paid statutory severance, and has complied with the law regarding payments due upon termination, the terminated employee can still pursue an unfair termination claim. In the case of a successful unfair termination claim, the court may order reinstatement. However, in practice, reinstatement tends to be uncommon if the court is aware that the relationship between the parties have broken down, or if the court is aware that the company no longer requires this employee. The more commonly imposed remedy for a successful unfair termination claim is damages. And when deciding the amount of damages, the court will take into consideration the age of the employee's years of service, the hardship of the employee when terminated, as well as the reasons for termination. And these are factors that will be taken into consideration when determining the amount of damages. Given the potential risk of an unfair termination claim and the fact that all employees have a right to pursue an unfair termination claim, it is important that company retains evidence to support the termination, especially given that the statute of limitation for an unfair termination claim is 10 years from the effective date of termination. The costs associated with filing a claim at the labor court for an employee are minimal, whereas for the company, litigation can be costly, time-consuming, and lead to unpredictable results. This means that when choosing to pursue with termination, the company should ensure that, firstly, accurate evidence is retained to support the termination in case that the company is left to be in a position of defending itself and defending the termination at the labor court. Secondly, it is also important to consider whether the dispute can be negotiated and settled as early as possible. To reduce the risk of an unfair termination claim, if it's a mass termination or when many employees are impacted, the selection criteria should be fair. The company should generally ensure that the grounds for termination is strong, accurate, and supported by evidence. Another way to mitigate the potential risk of an unfair termination claim is to consider an amicable separation. It is common practice for companies to offer additional monetary incentives, which we commonly refer to as an ex gratia payment, in exchange for an employee signing a release or a waiver document. However, this will depend on the negotiation and the agreement between the parties. The company cannot force an employee to agree to sign a release or a waiver document. However, with a successful negotiation, the employee may agree to do so, and this would generally be in exchange for the ex gratia payment, which will be paid on top of all the other money that the employee may have been entitled to, which means that the company may offer an additional ex gratia payment on top of the severance and on top of any payment in lieu of notice and other payments made upon termination. Now, I want to highlight the fact that the statute of limitation for these claims in Thailand is 10 years from the effective date of termination. And given how long the potential risk remains, it is essential that terminations are carried out in a manner that is compliant with the law and in a manner that minimizes the risk. The last obligation that employers have in the case of termination is to issue a certificate of employment for all the employees that have been terminated, and the certificate should state the length of employment as well as the nature of services provided by the employee. That will be all for Thailand for today. We can address any further queries during the Q&A session, but for now, I would like to pass over the webinar to my colleague Kun Jae from our Cambodia office. Thank you.
Well, thank you very much, Jusita. Let me just get my presentation teed up. Okay, terrific. Yeah, everyone, welcome to the Cambodian portion of the presentation. Today we're going to talk about, here's the agenda for today. We're going to start off by talking about some key concepts that will inform the rest of the presentation. We will talk about suspending labor contracts. That's something that might be a step before termination, depending on the needs of the company. So to jump into some of the key concepts that we'll be talking about. So the first concept I'd like to discuss is the concept of fixed duration contracts and undetermined duration contracts. So this is a really important distinction because when you think about terminating employees, step one is you need to know what kind of contract they have, a fixed term contract or an undetermined duration contract. So a fixed term contract, as the name suggests, is a contract with a precise starting date and a precise end date. And this contract needs to be in writing. Now, for a fixed term contract, we definitely see some companies that will have multiple fixed term contracts. So we'll have employees on fixed terms for 5, 6, 7 years. If that's the case, then under Cambodian law, the maximum duration of a fixed term contract is 4 years. If it's beyond 4 years, then it becomes an undetermined duration contract. And even for the 4-year rule, there's some rules around that in terms of what's the total duration of a fixed term contract. So the first step is to understand what kind of contract you're dealing with, fixed term or undetermined duration contract. Now, the second concept I just want to highlight has to do with probationary periods. So if you look at under Cambodian law, employment contracts can be subject to a probationary period. For most employees, that is 3 months. That would be regular office employees. Then you have certain categories of employees considered specialized employees. They have a maximum probationary period of 2 months. And then lastly, you have non-specialized employees, which has a probationary period of 1 month. And that would be like manual labor, unskilled labor. So if you terminate someone during a probationary period, then there's no need to give any sort of notice. So that's something we'll talk about a little bit later in the presentation. Then the last concept I want to talk about before we jump into the rest of the presentation is the concept of seniority payments. So employers now should be familiar with the concept of seniority payments. So these payments only apply to employees with undetermined duration contracts. So if you have employees that have fixed duration contracts, then seniority payments are not relevant. But if you have employees with undetermined duration contracts, then seniority payments are very relevant. And they require employers to pay employees a seniority payment twice per year in June and December. And the amount of that seniority payment is 7.5 days of wages at the end of June and in December for a total of 15 days per year. So also there's a concept of the ongoing seniority payment. So that's what you pay just right now. But also, if you employed your employees before 2019, then you would also owe them seniority back payments. So you also have to pay them a certain amount of seniority payments for time that they worked before 2019. So that's something to keep in mind. Many employers, maybe they've already paid that out, but if you haven't, you need to know, do you still owe them some of these seniority back payments? So the next topic we're going to talk about before we get to terminating employees is suspending employees. And the reason we want to talk about suspending employees is, often employers might come to us, they're having some financial difficulties, and they're considering, what should they do with their employees? Should they terminate them because of financial issues, or perhaps could they suspend them, which would, the employer would no longer have the obligation to make salary payments. They could kind of suspend the employment relationship for a certain period of time. And then at the end of that period of time, they could either bring the employees back on or then terminate the employees. But it can be a bit of a stopgap measure if employers are facing extreme pressures and they need some more time to sort of assess the situation, or they're hoping that after they overcome this short period of hardship, then they can go back to employing the employees. So for an employer to suspend an employment contract, there's a couple of reasons. So one, if employees have military obligations, then the employer can suspend the employment contract. So I know in Cambodia, there is some discussion of having mandatory military service for males of a certain age. So if the government ultimately implements that, then employers will have to suspend the employment contract during the period of the employee's military service. It is conceivable that an employer could suspend a contract for certain disciplinary measures. Then the one that we've just sort of mentioned, an employer can suspend the contract for serious economic or material difficulties. So if you think about during COVID, that could have been a period of time to suspend the contract. Maybe there was a lot of instability in the market because of tariffs. Conceivably, that could be a grounds for suspending contracts. So any sort of, extreme financial difficulties could be grounds for suspending the employment contracts of employees. Lastly, some sort of scenario where there's temporary layoffs. That could also be another ground for suspending an employment contract. Now, the employee also has rights to suspend an employment contract, and those are set out on the slide, so I won't repeat them. I'll just sort of notice one of the ones that sometimes is a little bit contentious is sick leave. So employees are entitled to up to 6 months of sick leave if they have serious illness. So I'll just sort of highlight that. And also, then you have things that are more, well understood, like maternity leave. Lastly, either the employer or the employee can suspend for force majeure. So you think about things like COVID-19, that could be force majeure. You could also have, serious floods or natural disasters, things like that. Now, when it comes to suspending an employment contract, there are some limitations. So if the reason for suspending the employment contract is economic reasons, then the employer can suspend for up to 2 months. And if it's for other reasons like force majeure, you think natural disasters, then you have a 3-month suspension period. If an employer is considering suspending the employment contract, there are some procedures around that. You have to notify the Ministry of Labor and Vocational Training, the MLVT. And then the Ministry of Labor and Vocational Training will have some labor inspectors assess the situation, and they will have to provide their approval of the reason of the suspension. So just sort of be aware that there are some ways to suspend the contract, but you do need to get some approvals. Now we're going to move into the portion that discusses the termination of employees' contracts and what kind of severance you'll have to pay employees. So at the very beginning, before we talk about termination, we do want to discuss grounds for termination. So there are 2 grounds. I mean, you can either terminate people for serious misconduct or for other reasons. So if you want to terminate for serious misconduct, then under the labor law, there are certain grounds that constitute serious misconduct. And if you sort of look at the list, you have things that you would traditionally think of: stealing, embezzlement, fraudulent acts, again, serious infractions of disciplinary safety and health rules, threats, abuse in the workplace. So I think some pretty standard reasons that might be considered serious misconduct. Also, if you're thinking about terminating employees for serious misconduct, a company should also look at their internal regulations. Some companies have also amended their internal regulations to expand the reasons, to expand what constitutes serious misconduct. And if your company has done that, then there might be other reasons that constitute serious misconduct. Now, the advantage of terminating somebody for serious misconduct is there's no need to provide notice. You can terminate people immediately, and later we will discuss some of the notice periods. However, if you do decide to terminate for serious misconduct, you need to terminate the employees within 7 days of learning of the serious misconduct. Now, regarding that 7-day period, many employers might require time to do an investigation. So again, it doesn't have to be 7 days of, the first suggestion that there might be serious misconduct. Employers can conduct an investigation. That investigation may take some time. And then once the employer concludes that an act of serious misconduct has taken place, then the employer can move to terminate the employee. If it is not a matter of serious misconduct, again, as we mentioned, if it's serious misconduct, there's no need to give any notice. But otherwise, if you want to terminate an employee for any other reasons, for poor performance, the employee is just no longer needed, then you have to give notice. Now, the notice period does depend on whether the employee has a fixed-term contract or an undetermined duration contract. So for a fixed term, as the name suggests, it is a fixed term. So you're not supposed to be terminating employees before the end of the fixed term. So then for fixed term employees, it's really a matter of like non-renewal. If you're not going to renew the contract, then you have to give them 10 days of notice. If if the contract duration is 6 months or less, if it's more than 1 year, then you have to give 15 days of notice that you're not going to be renewing the contract. Now, for an undetermined duration contract, then the notice periods are set out in the slide. So depending upon the length of service of the employee, you have to either give them between 7 days or 3 months of notice. Now, one point I'll highlight is you can always pay employees in lieu of notice. So, if you want to terminate a long-serving employee that's worked for more than 10 years, you could terminate them immediately, but you'd have to pay them out 3 months of notice. So I'll also say to the employers there, if you are looking at terminating employees and you want to minimize the amount of payments you have to make, then seriously take a look at the amount of notice you have to give them and ensure that you give employees proper notice. And then if you give them the notice, you won't have to pay them out. For the severance payments, there are really two kinds of severance payments. For fixed term contracts, if you terminate an employee, you have to pay them 5% of the wages they received during the length of the contract. So if an employee worked for 2 years, you look at all the wages you paid them during those 2 years, you would take 5% of the amount, and that becomes the severance payment for employees with fixed term contracts. Now, for employees with undetermined duration contracts, it's actually quite easy because now we have the ongoing seniority payments. So because you have the ongoing seniority payments, there is no other sort of like severance payment you have to pay employees. You just pay them the ongoing seniority payments. Now, one of the hot topics under Cambodian law is the concept of paying employees damages. So if the employer does not have a valid reason to terminate an employee, the employer will have to pay damages on termination. So the real question is, what is a valid reason to terminate an employee? The Ministry of Labor and Vocational Training has clarified what are valid reasons for terminating an employee. And the list is on the slide. And if you look at all of the reasons on the slide, they have to do with the business. Operational slowdowns, the company is moving towards bankruptcy, orders are canceled. If you note, it doesn't talk about the actual behavior of the employee. So if your employee has poor performance, isn't working very well, from the Ministry of Labor's perspective, that does not constitute a valid reason for terminating an employee. Now, I think this is actually one of the sort of the hot topics under Cambodian law, because employers will often say, look, if an employee is performing poorly, that should be a valid reason for terminating the employee. And the reason, again, it's a hot topic is because if the employer has a valid reason for terminating the employee, then they don't have to pay damages. But if they don't have a valid reason, then they have to pay damages. So that's a little bit of like the area where employees and employers often disagree. But from the Ministry of Labor's perspective, they would say that, a valid reason really only relates to the business and not the performance of the employee. So when we look at the amount of damages, then we have to look at how do you determine damages for fixed-term contracts and how do you determine damages for undetermined duration contracts. So for fixed-term contracts, if you terminate the contract early, then the employee receives all the amount of pay that they're entitled to the end of the contract's duration. So let's think about this. If an employee has a 1-year fixed-term contract and you decide to terminate them after 6 months, the amount of damages will be the amount that the employee would be entitled to if the contract was not terminated. That means that the employee is entitled to 6 months of damages because you terminated the employee in June, their contract ended in December, so their damages would be 6 months. So it's very expensive to terminate an employee with a fixed-term contract. And I think if you're an employee, you need to think very carefully about terminating them because the cost could be high. And the better route may simply be to just not renew the employee's contract at the end of their term. Now, for an employee that has an undetermined duration contract, the formula is different. So first off, if you terminate an employee with an undetermined duration contract, the amount of damages is the amount of all past seniority payments received. And there's no cap on that. So previously, there used to be a cap of 6 months of seniority payments, but that cap was removed in 2024. So now, if an employee with undetermined duration contract is entitled to damages, you have to look at the sum total of all the seniority payments paid to them, and that becomes the amount of damages. And remember, the seniority payments are approximately 15 days of wages per year of service. So you're looking at roughly 2 weeks of pay, 2 weeks of pay for every year of service. That would be about the amount of damages you would have to pay an employee with an undetermined duration contract. Looking at the entire severance package, it's on this chart. So if the employee has a fixed duration contract, if you look at the entire severance package, you have to pay the last month's salary, compensation in lieu of remaining annual leave, again, the 5% severance payment, and then damages. If you do it at the expiration date, you just do the last month's salary and compensation in lieu of remaining annual leave and the 5% severance. For employees with undetermined duration contracts, if it's termination without serious misconduct, then you have to pay an entire severance package that's last month's salary, compensation in lieu of notice, annual leave, a final seniority payment, which is 7 days of seniority pay if they've worked at least 30 days since the last payment, any unsettled seniority back payments and damages. So it can be a sizable package. It's something you need to think about in advance. And if there is serious misconduct, then it's a very simple package. It's last month's salary and remaining annual leave, a very simple package. There's also other severance packages if you terminate someone during the probationary period. Again, during the probationary period, there's no need to give them any notice. But if they have a fixed duration contract, you still have to pay them 5% of the wages they earned during the employment period, which might be very, very small because presumably they worked 3 months or less, and unused annual leave. Same for undetermined duration contracts. You have to pay them out for unused annual leave, but there's no need to pay any sort of seniority payments. So a very simple package. Lastly, when you terminate an employee, regardless of the reason, you have to provide them an employment certificate. It's a very simple certificate that has the starting date of employment, the date of departure, and what jobs they had. Now, the employment certificate also cannot make any statements that prejudice the employee. So again, just a very simple certificate that lays out some basic facts. I see we're running out of time. So I will note, if you are doing mass layoffs, if you think about like laying off all your employees or a significant percentage, 50, 60, 70, 80% of your employees, then special procedures do apply to mass layoffs. If you do that, there is an order to the layoffs. So you have to look at employees' professional qualifications, seniority with the company, and the family burden. You have to rank employees. Also, then you have to like notify worker representatives of these impending layoffs. So there's a little bit more of a procedure if you're looking at mass layoffs, and you need to do more communication with the employee representatives. But you can still do the layoffs. You just need to communicate, and you also need to rank the employees. So a couple of just like practical considerations if you are in a situation where you have to do layoffs. One, it's strongly recommended to get some legal advice first. So one, you understand all the costs involved. You understand what are the costs for the employees with a fixed duration contract, what are the costs involved for employees with an undetermined duration contract. Also to make sure that you have like all your documentation ready to go. So that would be giving people termination letters. Also, you can consider doing some sort of like mutual termination agreement where you clarify what the severance package will be. This might help you avoid paying damages also if you have some sort of like mutual termination agreement. Also, when you terminate employees, I think in your termination notice or in your termination agreement, it's always good to highlight any sort of ongoing obligations, like confidentiality obligations, to remind employees that even though they've been terminated, they still need to maintain any sort of like confidentiality obligations that they have. It's also good to ensure that all company property has been returned. That's also very important. Are there any laptops, phones? But then also think, do they have any other things in their possession? Do they have any materials, marketing materials, reports, other documents that should be returned? Also, if you are doing like layoffs of like multiple employees, we've had a number of companies that have come to us and asked to also have like a lawyer present. So when the company notifies the employees of the layoffs, they'll also have a lawyer present to answer questions on severance. So then, employees' questions can be answered there on the spot. That brings me to the end of my presentation. If you have any questions, I'm happy to answer them at the end of the session. So now I will turn this over to my next colleague.
Thank you, Jay. Hello, everyone. Today, I'll be presenting about Lao law perspective regarding termination of employment. So termination is one of the most important on the employment labor in Laos, and mistake can be caused to the dispute and penalty. The goal of the presentation today is to help you to understand and compliance with the Lao law. So about my presentation today, I'll walk you through the main issues. The first one is overview of employment termination under Lao labor law. And second is termination process, notice requirement, assurance pay. And the third is obligation for both employers and employee when terminating employment. And the last issue will be dispute resolution pathway and common pitfalls. So let's start with the overview of employment termination. Termination of employment in Laos is governed by the Lao labor law. Termination can occur in any events, for example, in case of mutual agreement, fixed term contract end, a redundancy, or dismissal of for cause. And the law distinguishes between the termination initiated by the employer and that initiated by the employee. with specific procedure and protection in place for each scenario. So let's talk about the type of termination of employment. In Laos, there are two main types of termination of employment, which is justified and unjustified termination. For justified termination, it could be in ground of redundancy or business reason, for example, company restructuring or business closure. And another ground could be in the case of employee lack of skill or employee under the health issues. And for the unjustified termination, the termination could be in ground of the termination without sufficient reasons. For instance, employer unilaterally termination employment immediately without providing any reasons, or even have been providing reason, but it is not a proper reason. So in this case can be considered as unjustified termination. Or in the case where the employer abuse of power of employees or infringements of the employment contract. So these cases could be considered as unjustified termination. Under Lao labor law, employers are protected in the following cases, as you may see in the slides. For example, in the case that employee is pregnant or has a child less than 1 year of age, or in the case that employee is undergoing medical treatment or rehabilitation supported by a medical certificate, or in case that the employee is a representative of employees or the head of trade union in the labor unit, or in the case the employee is on annual leave. So about the termination of employment, the process for termination would be in the ground of varied reasons, such as the gross misconduct, redundancy, or employee inability to perform their duties. And the process of termination generally requires documentation. For instance, warning or written notice. And some case, the approval from the labor administration authorities is required. For example, in case of redundancy. So these are the procedure for termination of employment, but actually these are the procedure like on the termination by the employer. As an employer, you should have the valid reason before terminating employment and clearly identify the reasons. Apart from that, providing the written notice, and you have to strictly follow the disciplinary process, which will be stated in the employment contract or work rules. And for some cases, you must consult with the relevant authority, as I just said, the labor administration authority. And to make sure that the calculation and pay final dues should be correct and compliance with the labor law. And another one, this is also important, signing the mutual agreement before terminating the employment and issuance the employment certificate within 7 days after the termination end. About the notice requirements, so employer and employees can terminate the indefinite term contract by providing advance notice. However, for the fixed term employment contract, the notice may not be required if both parties terminate by the mutual agreement or if either party has breached the contract. Let's talk about the notice period requirement. Under Lao labor law, the notice requirement is 30 days applied for the employee performing physical labor and 45 days applied for the employees performing mental labor. So about severance pay. Employees who are terminated without cause are generally entitled to severance pay. The amount is depending on the range of service or reasons for termination. If in case of unjustified termination, additional compensation may be required. So in which case, termination must be paid. In Laos, if employer terminates for reason not related to gross misconduct, the severance pay is required, or in case of redundancy or layoff, or in the case of employee lack of skill, and you have evidence to prove that that employee have the lack of skill and cannot perform their duties. In this case, you can terminate the employees, but the severance pay is required. With cases, termination is not required. It would be in the ground of employee caused deliberate damage to the employer, or in case that the employee repeats violate internal regulation or employment contract and has been warned at least once by the employer. Employee was absent from work without any proper reason for 4 consecutive days. And in case that employee has been sentenced into the imprisonment for offense perpetrated deliberate against the labor unit. About the statutory severance pay, Lao labor law specify about the severance pay for justified termination is 10% of the employee last month's salary multiplied by the number of the months that employees work. While unjustified, it is 15% of the employee last month's salary multiplied by the numbers of months they work. In addition, in case that employee receiving unspecific wages, for example, if they receive the wages from the units of production, the average of the calculation would be in the average of the last 3 months' wage as the basic of calculating. Apart from statutory severance pay, there are also compensations requirements. For instance, payment in lieu of notice, if any, or unused vacation or annual leave, and other benefits under the employment contract or work rules. Moving forward to the obligation of employees and employer. So regarding obligation of the employer, you must provide a legal valid reason. Secondly, ensure that procedure is fairness. And also, you must provide the advance notice, as I just mentioned, and ensure that all outstanding wages, severance pay are provided to the employee. In addition, the payments must be finalized and provide mutual termination or release agreement to your employee to ensure that there won't be any claim after termination. And this is also important to provide the employment certificate within 7 days after termination. About the obligation of employee. As an employee, you must provide written notice along with submission written resignation. And also, before leaving, you should hand over your task or project to your line manager or supervisor, and also return all the company properties. Let me briefly about the dispute resolution pathway and common pitfall. In Laos, if labor dispute arises, termination parties are encouraged to resolve it through negotiation or mediation. If unresolved, the matter can be brought to the Labor Dispute Committee or to the courts. What you can see is the common issue in Laos, which includes of lack of valid grounds, employer fail to follow the procedures. Also, non-documentation and termination of the protected employees. Another issue would be employer fail to provide statutory surveillance and fail to maintain proper documentation. So to wrap up, let me summarize about what we have solved. So in Laos, there are two types of termination, which is justified and unjustified termination. For justified termination can be in case of valid legal reasons, and while unjustified is in case of the not valid reason. Under the labor law, the notice requirement is required before termination of employment, and 30 days apply for the physical laborers, while 45 days apply for the mental laborers. Severance pay for justified termination is at rate of 10%, while unjustified is at rate of 15%. Employer must ensure that all legal obligations are fulfilled when terminating employment. And also for the dispute resolution, parties are encouraged to resolve it through negotiation or mediation first. If unresolved, the matter can be brought before the labor dispute resolution or the courts. The common issues include of failure to provide adequate notice, improper documentation, or non-payment of severance, and not following statutory procedures. So, ending of employment relationship is quite serious. But by following this procedure, you and your employees will be can help you to ensure that there will be no claim later. Thank you for your attention today. So for now, I would like to pass the mic to my colleagues from Myanmar office, New.
Thank you, Stephen, for introducing me. Yeah, everyone. Good morning, and I'm Rao from Senior Associate from the Legal Engagement Myanmar Limited in Yangon. And today I would like to discuss about the legal framework in Myanmar for the termination of the employment. So today I would like to focus on the importance of the understanding the Myanmar legal framework for the employment and the termination. And also I would like to emphasize that in Myanmar, there's no concept of the fire adult, and all the termination must have the legal and contractual procedure, and also must have the valid ground for the termination. So for the key points, I will discuss about the legal frameworks, type of termination, required procedures, and the practice for the compliance by the employer and employee. In Myanmar, there are no unified code or law for the labor and for the labor related matters. There are a lot of many labor laws. That's why another for the specific matters such as compensation for the matters under the Workmen's Compensation Act is enacted since 1923, and also the regarding the leave and holidays is under the Leave and Holidays Act 1951, Factory Act 1951, Security Law 2012, Settlement Labor Dispute Law 2012, Employment and Skill Development Law 2013. That law governed for the requirement of the employment contract, and for the minimum wages under the Minimum Wages Law 2013, and the payment of wages law is regulate for the how to make the payments and which time to the employee. And so shops and establishment law, this relate to the office establishment and the shops and labor organization law. Addition, in Myanmar, Ministry of Labor also issue the notification and direction about the severance payment is required under the Employment and Skill Development Law, and also the labor related matters, as well as the mandatory employment contract template that must be used or the employment contract in Myanmar. So unfortunately, there are no provisions or the regulation about the termination under those statutes, laws, or regulation in Myanmar. So about the termination, employment termination, there's a question how we will practice for such termination. So according to the Ministry of Labor notification number 4 and 2017, the government and the labor authorities issue mandatory employment contract template to be followed by all the labor industry in Myanmar. This employment contract template has the provision about the resignation or termination. So this employment contract form is prepared by the tri-party discussion. This means labor authorities, labor union, and the employer association in Myanmar, and first introduced in 2015, and 2017 is modified for the current template and must use all the labor industry in Myanmar. So according to this notification, we have to use this employment template contract form, and all the employment must be registered with the relevant labor township labor office and within 30 days from the employment. And this, if we do not register this employment contract with the labor authorities, this way subject to the imprisonment or the fines to the employer. So under this mandatory employment contract template, there are many key provisions about job title, promotion, salary, work location, working hours, resignation, termination, and other provision. And for the employer and employees, we cannot amend or modify this template, and we just require to insert the information of the employer and employee, job title, whether provision or not, and the salary amount, location of work, only this minimum required information. Or other terms and conditions we cannot modify or amend. So again, while I emphasize on the basic concept about the termination, the labor authorities in Myanmar do not accept the concept of the fire at will. All the termination must be made in accordance with your template labor contract or law or other valid cause, and all the employers must follow the termination process that already emphasis and the template contract form. And if the termination is made without cause or process, it is not recognized legally. So under the employment contract template, there's two parts of the employment separation. One is the resignation from work by the employee, and another one is termination by the employer. So resignation from work by the employee must provide at least 1 month notice before the resignation. And as usual, all resignation, the employees must return all the common properties, and if possible, must assign to the other colleague of the company about the work related matters. And even the employee resign from the company or employment before the end of the contract period, and they must follow some point already provided under the employment contract template. This is if the resignation, the employer do not require to pay the severance payment for the tenure of the employee, but this depends on the employer whether to pay the severance payment or not. But if the employer do not pay, there will be no issue. But if pay, the employer will be happy. So about the training within the employment term, if the employment attend the training by the cost of the employer and resign before 10 years, 3 years, there may be some, the employee should make some compensation to the employer. But if the resignation is made after 3 years of the attending employer sponsor training, no need to pay for the compensation. So another one is part of the employment contract template is the termination. So termination may be 3 types. One is the termination by employer for the gross serious misconduct of the employee. Another one is the termination based on the non-gross, non-serious misconduct. But for this non-gross, non-serious misconduct, the employer must follow the 3-step warning. First, forward warning for the first misconduct. Second, written warning for the second misconduct, and third, written warning and acknowledgement by the employee for the third time of the misconduct. And after the 3 times of misconduct and the employee commit again other misconduct during 12 months period of the third time, then the employer can terminate as the serious misconduct without paying the severance pay. But after 3 warnings given and the employer will not commit again within 1 year, the employer must cancel the first 3 warnings. And if the employer commit again after 1 year from the third warning, must start again from the first warning. So according to the employment contract, as I said, Myanmar has no legal provision about the termination of the employment, and the provision of the template employment contracts regulate as the industrial norm or industrial practice or for the termination of the employment. So under this employment contract form, as I discussed, especially two types of the resignation termination. One is a resignation by the employee, dismissal by the termination by the employer, and another one is the termination of the agreement. So resignation is usually the employee given 1 month notice, return all company property. There may be no severance. If the employer agree for the some certain severance payment, there will be severance payment. And for the dismissal, as I discussed, for the gross misconduct, if employee committed, the employer can dismiss immediately without severance payment. For the non-gross misconduct, the employer must provide 3 times of money, and on the full time can dismiss the serious misconduct and without severance payment. And for the immediate dismissal or for the serious misconduct, mostly the very serious case such as theft, stolen of the company property, or violence, or riot at the workplace, and using drugs at the workplace, such as these are considered as the serious misconduct. Other termination agreements, this depends on the situations of the business of the company or the employer, and if the employer or company undergo for the liquidation of work stopped for the under the force majeure issues. So another one is that employee. So terminate the employment agreement may be terminated on this ground. Again, I would like to focus on dismissal for misconduct, gross misconduct, no notice or severance required, but the employer must have documents on the misconduct and also required to notify to the labor office about the termination of the employment. And if the termination by notice, usually from the employer or employee must provide the 1 month prior notice, or if there's no 1 month prior notice by the employer, the employers can be paid main lieu of the notice. And if termination by the employer, must pay severance payment as the notification by the Ministry of Labor. And for the redundancy or the business closure, the employer and employee must first discuss about the layoff, the redundancy or business closures, and if required, should discuss at the workplace coordination committee or labor organization, and also must provide the severance payment to the employee. So usually employee resignation or employee voluntary resignation does not require for the severance payment. If the employee agree for severance payment, must provide on this employee voluntary resignation. So as I discussed, there's no written provision under the labor, various types of labor laws about the termination, and most of the termination process is governed by the provision of the mandatory employment template form, and that's why if the employer consider for or phase into the employment termination process, all the employers or the HR officer must sure to have any proper documentation and record of all the reason for the termination. If required, coordinate with the WCC and labor organization, and check whether it's required to comply with the statutory notice or severance requirement. And after the termination, notify to the local labor office and avoid fire away or discriminate or the arbitrary dismissal. So one of the reason on the terminations is on probation. Actually, in the employment contract form, there's no specific provision for the termination of probation, but the under the employment contract practice and the contract forms, the probation period not to exceed 3 months, and employer can provide 1 month notice for the termination or payment in lieu of the notice, and the employees in probation can resign with 7 days notice. And during the probation period, the employer can pay at least 70% of the business salary to the employee in probation. So again, for the gross misconduct, the employer can make the immediate dismissal and require no severance payment. For the non-gross misconduct, employer must provide the disciplinary warning for written or fine. And if the dismissal is repeated then you can dismiss the employee if repeated within 3 months from this 3 warning. So under the business closure, it's the usual that the company can lay off or dismiss the employment for the reason of liquidation or force majeure business dissolution. So require this for this type of the business termination or laid off on the business closure, required to negotiate with the employee or their representative, and required to pay the the severance payment, and also required to register or to notify with the local labor office. For the severance payment rate, is based on the length of the service tenure of the employee, and such as what from first day to 6 months not required for the service payment, but the 7 to 1 year is 0.5 1/2 month salary. For 1 to 2 years, 1 month salary. 2 to 3 years, 1.5 salary, and the maximum is if the employment tenure is over 25 years, is required 30 months salary pay for the severance payment. So for the best practice for the employer, yes, as usual, maintain a clear written employment contract, but in Myanmar must use the mandatory employment contract form and not authorized to use the in-house style employment contract. And all the disciplinary action taken by the employer must be documented, and also provide the reasons for the termination. If required, must provide the notice of advance notice, or if not provide the notice, can provide the payment in lieu. And on the termination, as usual, must provide all the statutory dues such as arrear wages and use leave, severance payment, and if possible, issue the certificate of employment on termination. And also, as usual, please notify or register to the local labor office on this termination. as the separate note, most of the labor dispute first settled at the workplace coordination committee. If not, can refer to the township labor dispute settlement or an labor arbitration body, and finally labor arbitration council. And if not satisfying the decision of the labor arbitration council, we can submit writ to the Union Supreme Court for the final decision. So finally, I would like to have some key points and key takeaways. For under the legal framework, especially in accordance with the labor practice and the provision of the labor employment contract template, all the termination requires for the provided process and not the labor authorities not accept fire at will, and termination of the employee must have the valid reason and the cause, and the employer must maintain proper documentation, compliance procedure, and negotiation if required, and follow the practice and legal of the workplace coordination committee, and also must follow with the accordance with the labor practice and also the industrial norms, and also the provision of the employment contract form for the for compliance of the termination process. So all the question and answer will be addressed at a later stage, and now I would like to invite Ms. Sarah for Vienna. Thank you.
Hello, my name is Sarah Gillespie, and I'm counsel in the Ho Chi Minh City office of Tilakee and Gibbons. Next slide. So my presentation focuses on unilateral termination by the employer because termination is very complicated in Vietnam. And frankly, if I covered resignation and mutual termination, we could not fit that into 20 minutes. So unilateral termination by the employer, it follows these bases: poor performance, where the employee provided untruthful information during the recruitment process, where the employee has been absent from work for at least 5 consecutive days without a justifiable reason, redundancy, and dismissal. And I'll also discuss the consequences of illegal termination. Next slide. So we'll start with poor performance terminations. The Labor Code states that an employer may terminate an employee if the employee repeatedly fails to perform his or her work according to the criteria for assessment of employees' fulfillment of duties established by the employer. What this basically means is if an employer wants to terminate an employee due to poor performance, in advance of the employee's poor performance arising, they must have in place a criteria for assessment of the employee's fulfillment of duties. This is often referred to as performance management policy. If a corporate trade union exists at the organization, the performance management policy must have been consulted with them in advance of the poor performance occurring. And it would also have to be subject to a dialogue in the workplace session before it can be effective. And a lot of my clients are not very familiar with this. There's a requirement under the Labor Code that went into effect in 2021 that for most major labor management steps, that the employer consult with the employee dialogue representative group. And this is distinct from the corporate level trade union. Basically, the employer is supposed to have in place what's called a workplace democracy policy. And this sets out how the employee dialogue representative group is established and the procedures for undertaking these dialogues in the workplace and for holding employee conferences. And for many steps, such as putting in place a performance management policy, it's necessary to hold one of these dialogue sessions. So if your organization doesn't already have a workplace democracy policy or doesn't have an employee dialogue representative group, I would encourage you to do so as soon as possible so you can have the proper policies in place, which is essential for unilateral termination. Another consideration is that employers should have detailed job descriptions in the employees' labor contracts. Because if you look at the clause from the labor code, it states they must repeatedly fail to perform their work, and you need to establish that this is part of their job duties, that they should have been performing this. Next slide. So since the law requires that the employee must repeatedly fail to meet expectations, employers generally have to follow a particular process to go ahead with a poor performance termination. So first of all, the performance management policy should specify the evaluation period. This is normally biannual or annual. However, you can also incorporate into the policy that it can include ad hoc incidents. If the employee receives an unsatisfactory rating, the person should receive a warning letter and be placed on a performance improvement plan, commonly referred to as a PIP. And the PIP will set objectives for the employee to meet within a certain period, and it's usually 1 or 2 months long. These types of goals that the person should have to achieve should fit the SMART criteria, so be specific, measurable, actionable, etc. After the first PIP is completed, then there's an evaluation process. If the employee has performed satisfactorily, then they can be released from the process. If they have not successfully completed their goals, then the employer should place them on a second PIP. This is to show the employee has repeatedly failed to perform their duties. And then another evaluation would be held after that. So if they meet the goals in the second PIP, they're released from the process. If not, then the employer may issue a notice of termination. Next slide, please. So for termination based on poor performance, these are the notice periods that are applicable. If the person has an indefinite term contract, it's 45 calendar days. If it's a definite term contract of 12 to 36 months, 30 calendar days. And if it's a definite contract under 1 year, it's only 3 working days. And employees are entitled to statutory severance allowance for working periods not covered by unemployment insurance, even in the case of a poor performance termination. Next slide. Next slide. All right, so just for an example, we have a case study here. Hypothetically, let's say you have an employee named Min with an indefinite term labor contract who is rated unsatisfactory at his annual performance evaluation. Your company would like to terminate his employment as soon as possible. You have a performance management policy in place that has been consulted with the trade union and subject to a dialogue in the workplace session. What is the minimum amount of time required to terminate his employment from the time of the performance evaluation? So please just type your hypothesis in the chat, and then I'll tell you the answer in just 1 second. Okay, I see we're short on time, so we can just move. Next slide. So this would take 3.5 months to complete the entire process. So keep in mind, after the negative performance review, Min must have 2 opportunities to improve his performance, each lasting for at least 1 month. Then if he fails those opportunities, you would have to give him 45 days notice. And what other approach is available? Anyone can type in the chat if they have an idea. Okay, I'll just tell you because we're tight on time. Basically, you could try to negotiate mutual termination. And to be honest, in Vietnam, I have never seen a poor performance termination go through from beginning to end. Usually the parties negotiate mutual termination while the employee is on a PIP. Okay, next slide. Okay, so now we'll move on to the situation where the employee provided untruthful information at the recruitment stage. So this is somewhat new. This was just introduced with the labor code that went into effect in 2021. And now an employer may terminate the labor contract where an employee failed to provide truthful information in a manner that affects recruitment. And so this would include things like false information on their education, false information on their occupational skills and qualifications, untruthful information about a health condition, or some other issue directly related to the labor contract. So for example, if you were trying to hire a foreign employee and they said they had no criminal record, but they did, then they would not be eligible for a work permit. So it would affect recruitment. So even if the employee has lied during the recruitment stage, the employer must still provide notice. And these are based on the same notice periods that apply for poor performance terminations. So that would be 45 days for an indefinite term contract, 30 days for a contract of 12 months to 36 months, and 3 working days if it's under 1 year. However, one important point to keep in mind is that if the employer discovers the untruthfulness during the probation period, then the employer can terminate the employee without notice or compensation. And so for the probation period will vary depending on the type of job. So it's 60 days for a job requiring a university education, 30 days for a job requiring vocational education, and 6 working days for a job not requiring any education. And then for an executive position like a general director or deputy general director, it can be up to 180 calendar days. And the other point to keep in mind is that even in this case, statutory severance allowance may apply for any periods where the parties were not participating in unemployment assurance. Next slide. This is another ground. The employee is absent from the workplace for a period of at least 5 consecutive days. This was just introduced in the labor code that went into effect in 2021 as well. So basically, if the employee does not attend the workplace for 5 consecutive working days without proper reasons, then the employer can terminate them without notice and without any payment of severance. However, proper reasons include things like natural disasters, fires, if the employee or a family member suffers an illness with a medical certificate, or if the internal labor regulations specify other proper reasons. So in my experience, this can often be challenging because perhaps the employer thinks that the employee has not come to work with any kind of proper reason, but then the employee says, oh, actually, my child was sick. Here's a medical certificate. So actually relying on this ground in practice can sometimes be risky. Next slide. We'll move on to redundancy terminations. Next slide. Redundancy terminations are quite complicated in Vietnam. First, the employer must establish a legal basis for the redundancy. And so this usually includes change in organizational structure, technology, or products. So basically, the employer has to kind of justify their business reasons for proceeding with redundancy. Economic reasons is another listed ground under the labor code, but it's very hard to meet this ground because it means an economic crisis or depression or changes in law and state policies. So actually proving the validity of the economic reason would be kind of uncertain and risky. So I've not seen many redundancies proceed on that basis. And then also separation, division, consolidation, merger of enterprises, or asset transfer can also be a legal basis. In redundancy terminations, employees may be entitled for job loss allowance for working periods not covered by unemployment insurance. And job loss allowance is 1 month per year of service, whereas severance allowance is only half a month's salary per relevant year. And also the law says employees should be entitled to a minimum of 2 months' salary for job loss allowance. And the way the law is worded is kind of ambiguous. So we recommend to pay this 2-month minimum, even in the case where the entire working period has been covered by unemployment insurance. Next slide. So there's a number of steps to carry out a redundancy termination. It's actually quite onerous, and it takes roughly 2 months to 2.5 months. So first, the company's investor needs to issue a resolution regarding the reorganization. Then the legal representative of the company would issue a resolution to reorganize the Vietnamese entity. Then the company needs to form a labor usage plan, and this sets out the legal reason for the redundancy and lists the employees who will be retained, retrenched, retrained, and the financial means to settle obligations to employees. And this is created in consultation with the corporate level trade union if one exists. Step 4 is consulting with the corporate level trade union if one exists. And step 5 is again holding this dialogue in the workplace session with the employee dialogue representative group. So that was what I mentioned before, that it's important to have the workplace democracy in place and the employee dialogue representative group, because this dialogue in the workplace step is required for basically any major labor management step. For step 6, then it's important to notify the People's Committee and the employee at least 30 days in advance of the termination date. And then step 7, the company would issue a termination decision, and this could be done together with step 6. And then step 8 is settling the employee's termination entitlements. So you can see it's a long process. What we normally recommend is to first try to negotiate mutual termination before undergoing all these steps, because in addition to being very time-consuming, redundancy terminations are very risky in Vietnam. The authorities in the court will often question whether the redundancy is genuine. Next slide. So just an example, let's say your company, ABC Limited, wishes to terminate one employee on the basis of redundancy. What positions do you think cannot be made redundant? And what are some concerns with this approach? Basically, if the person is a chief accountant or general director, this person cannot be made redundant. These positions are always needed. And another thing to keep in mind, if it is some kind of key position that your company needs, if you terminate someone on the basis of redundancy, and then shortly thereafter hire someone new to replace that position, the redundancy will probably be found to be unlawful. So that's very risky. The company employers also have an obligation to retrain employees for other vacant positions in the organization if they exist. Another consideration with a one-person redundancy is that it's not legally required to form a labor usage plan, but it is best practice to follow all redundancy steps, even if only one employee is impacted. And then please note that the authorities will view redundancies involving one person very suspiciously, so it's very risky. Next slide. Okay, dismissal. Dismissal is very limited in Vietnam. And while the new labor code states that disciplinary action can be applied where the misconduct is in the ILRs or the labor law or the labor contract, in practice, judges will not follow that in our experience. So basically, you need the employee's misconduct to be listed in your internal labor regulations. And these are the registered working rules of the employer. For dismissal, there's no severance allowance and no notice. Next slide. So the following are a legal basis for dismissal. Some acts of misconduct do not require the employer to prove monetary damages. These are theft, embezzlement, gambling, assault, use of drugs at the workplace, disclosure of confidential information, infringement of IP rights, or sexual harassment. But for any other act of misconduct, it's necessary to show that it causes a certain level of monetary damage that should be listed in the internal labor regulations. So this can sometimes result in kind of frustrating outcomes because, for example, if your employee has committed an act of bribery, you may not be able to prove monetary damage arising from it, but at the same time, it's a serious act of misconduct. Another ground for dismissal is if the employee is already being disciplined by a deferral of salary increase for 6 months or demotion, and they recommit the offense, well, they're still subject to that disciplinary action. And you can also dismiss an employee if they are absent from the workplace 5 days off in a month. So if you have the option, it's more convenient to unilaterally terminate them if they're gone 5 consecutive days, but let's say it's 1 here, 1 there, or a total of 20 days off in 1 year without a proper reason is also a ground for dismissal. Next slide. So one thing with dismissal is it's important for the employer to keep in mind they must hold a disciplinary hearing. And this involves notifying the employee as well as the corporate level trade union, if one exists, at least 5 working days in advance. And then holding a hearing where the employer presents evidence of the misconduct, and then the employee and the corporate level trade union have an opportunity to comment. But the employer ultimately makes the decision independently as to what type of disciplinary action would be applied. Short limitation periods apply. So for most acts of misconduct, it's only 6 months from the occurrence of the act. A longer period of 12 months applies where the misconduct involves the employer's finances, assets, or disclosure of confidential information. But keep in mind that the limitation period starts to run from the occurrence of the act rather than from the date of reasonable discoverability. So this can be kind of result in unfair outcomes sometimes. If, for example, an employee has been secretly stealing the employer's confidential or money, and the employer only discovers this, but too late. Another consideration is that the disciplinary hearing and the issuance of the disciplinary decision must occur within the time limit. Next slide. So we'll briefly go through the consequences of illegal termination. So if the employee brings a lawsuit and wins, there's mandatory reinstatement of the employment, which can be a very uncomfortable situation. And then there's back pay for the period during which the employee could not work, including statutory insurance contributions. A 12-month limitation period applies to employees to bring a lawsuit. So employees will often wait for the 12 months to almost end and then bring their lawsuit, basically so they could get back pay for that 12-month period. They also are entitled to payment for at least 2 months' salary for emotional distress. And if the employee decides not to come back to work, the above amounts must be paid, plus at least 2 months' salary and severance allowance. However, keep in mind, in practice, usually the employer is paying much more because the employee must agree not to come back. So often they demand really exorbitant sum of money for this. Next slide. There's also practical concerns with illegal termination. Lawsuits often take 1 to 2 years to complete, and they entail significant, legal costs. Illegal termination can also damage an employer's reputation. There are labor newspapers that publish stories about illegal terminations. And then employees also have less to lose in the case of a labor lawsuit. Many lawyers will work on a contingency basis, and even if the employee loses their case, they are not responsible for the court fees. Only the employer will bear them if the employer loses the case. Next slide. Okay, so that's the end. Just as a quick concluding remark, I would say when you're faced with a situation where you may unilaterally need to terminate an employee, it's much better to try to negotiate a mutual termination agreement. So as you can see, the procedures are very complicated, basically for most types of unilateral termination, and there's significant risk involved. So I would encourage you to try to negotiate a mutual termination agreement.
Thank you, Sarah, for those valuable insights for termination of employment under Vietnamese law. So that concludes all 5 jurisdictions in today's sessions. Okay, so we have now come to the end of today's presentation. So I would like to take a moment to thank you to all our speakers and attendees for joining us today. And thank you everyone, and hope to see you guys next time.